cakes. Good evening and thank you so much for joining us tonight at 6. I'm Anna Darling. KNWA is your local election headquarters. Arkansans will not be seeing an abortion rights amendment measure on the ballot this November. The state Supreme Court ruled today that the group Arkansans for Limited Government failed to meet the guidelines for submitting documentation that proves paid canvassers had been trained on state election laws. Our Caroline Derby explains what happened with the Supreme Court ruling.
The state Supreme Court ruling Thursday in favor of Secretary of State John Thurston after the group Arkansans for Limited Government, trying to get the abortion amendment on the November 2024 ballot, sued Secretary of State John Thurston after his office rejected their petition signatures. The main reason behind the rejection has to do with the documentation about paid canvassers who were gathering petition signatures. Attorney General Tim Griffin represented Secretary John Thurston in the suit.
And it basically says, when you file your paperwork, your signatures as a ballot campaign, you must turn in a document that says you trained your paid canvassers.
According to the ruling, AFLG leaders did not submit a single full list of canvassers noting their training with the petition signatures they turned in on the deadline of July 5th. Rebecca Bobrow, director of strategy for the group, says they submitted running lists multiple times before the deadline.
We just didn't hand that piece of paper into the Secretary of State's team with the signatures on July 5th.
The majority of justices say that these earlier partial submissions did not meet state law, which the justices said required a single full list. The court was divided on this 4-3. In the dissenting opinion from Justice Karen Baker, she says the Secretary of State seems to be following different protocols for the different measures across the board, which Bobrow agrees with.
Hearing that, that the court is not acting properly and has kind of ruled in a way that's silencing 102,000 voters is upsetting and frustrating.
The AG says he believes the law is clear on this.
This year, the casino folks did that properly. The marijuana folks did that properly on this particular requirement, and the abortion people didn't. That's what we've said from the beginning, and the court agrees with us.
That was our Caroline Derby reporting. The Family Council Action Committee has released a statement praising the ruling, saying in part that the abortion amendment, quote, legalizes unrestricted abortion for any reason during the first 5 months of pregnancy. The amendment does not contain any medical licensing or health and safety standards for abortion, and it does not require abortions to be performed by a physician or in a licensed medical facility. You can read that entire statement and other statements from people and organizations for and against the ruling over on our website, knwa.com.